facts but different findings in lawsuits alleging insurance fraud by AARP. By Patricia Barnes. The AARP is fighting case by case to defeat claims that it cheats consumers who purchase AARP-branded Medicare supplemental health insurance, Medigap, products by charging illegal commissions. A nonprofit organization that claims to advocate for Americans age 50+, the AARP is facing several lawsuits around the country, including a Washington, D.C. lawsuit that is moving forward as a class action lawsuit and 2 proposed California class action lawsuits that are, for now, at least, not. Since at least 1997, the AARP has held, in its name, group Medigap policies underwritten by United Health Group and United Healthcare Insurance Company. For each policy purchased and renewed, the AARP charges an undisclosed 4.95% fee that it maintains as a royalty to compensate AARP for United Health's use of its intellectual property. The plaintiffs in lawsuits against the AARP say it is actually charging a commission, but disguising it as a royalty, to avoid oversight by insurance regulators and to avoid paying taxes on the income generated through insurance sales. The rulings below reflect the dramatically different analysis of the facts by 2 federal judges in Washington and California. Class action proceeds. U.S. District Judge Beryl Howell of Washington, D.C., last fall ruled the case of Crocus versus AARP, Inc. et al. Can proceed as a class action against the AARP, which is headquartered in Washington. She rejected AARP's argument the lawsuit should be dismissed because it would force the court to second-guess insurance rates approved by state regulators. Judge Howell said the plaintiffs are not challenging state-approved rates but allege the AARP used unfair business practices and deceptive conduct that prevented consumers from making informed decisions about the cost of AARP-branded insurance. Judge Howell said the AARP does far more than simply endorse United Health Medigap policies. She ruled the plaintiffs provided ample detail concerning AARP's extensive responsibilities to allow the reasonable inference that the defendants are merchants. Judge Howell also rejected the AARP's argument the plaintiffs suffered no injury. She said the lead plaintiff, Helen Crocus, a Boca Raton, Florida, resident, adequately alleged the AARP's misrepresentations or omissions regarding the nature, cost and purpose of the 4.95% charge, affected her understanding of the cost of her Medigap insurance. She has further sufficiently alleged that this misrepresentation was intended to induce consumers to purchase AARP-sponsored Medigap insurance over other policies that offered identical benefits, writes Howell. Summarily dismissed. By contrast, Senior U.S. District Court Judge Dean D. Pregerson of Los Angeles summarily dismissed 2 proposed class action lawsuits filed against the AARP in California. Judge Pregerson in 2018 dismissed the case of Leve versus AARP, without allowing the plaintiffs to engage in discovery, and did so with prejudice, so the case cannot be refiled. The plaintiffs have filed a notice of appeal with the U.S. Court of Appeals for the Ninth Circuit in San Francisco. The 3 named plaintiffs in Leve allege the AARP exploited its nonprofit status as an advocate for older Americans to sell Medigap insurance products as best for seniors. Judge Pregerson called the AARP's characterization puffery, that was not fraudulent under state and federal consumer protection laws. Calling the insurance plan best for seniors was puffery, not fraud. Best is a problematic word because it is vague, highly subjective, and lacks the specific of absolute characteristics required to state an actionable misrepresentation, writes Judge Pregerson, who is semi-retired. The plaintiffs said they paid membership dues to the AARP because it said it protected seniors and that it put their interests first ahead of for-profit business venues. Instead, they argued, the AARP sells its name to the highest bidder. Judge Pregerson ruled the AARP's representations did not create a legal duty to act in the best interests of members. Plaintiff Simon Leve said he was offered the same or similar policy from New York Life, outside of AARP, at half the price. Judge Pregerson said Leve did not allege how the 2 products may have compared. The court should not be required to speculate what same or similar means. Regarding the AARP's undisclosed 4.95% fee, Judge Pregerson said, it would be foolish indeed for an enterprise, regardless of its status as a non- or for-profit entity, to be blind, all other factors being substantially equal, to revenue-generating opportunities. Appeals Court Circuit decision? it's not clear how Judge Pregerson's ruling in the Levy case squares with a 2017 decision by a three-judge panel of the U.S. Court of Appeals for the Ninth Circuit in response to Judge Pregerson's dismissal of Friedman v. AARP, Enkel, et al., which also challenged the AARP's Medigap insurance program. The appellate panel ruled the AARP transacts and solicits insurance without a license in violation of the California Insurance Code and engaged in deception and fraud by calling the 4.95% commission a royalty. The panel also found the plaintiff had demonstrated injury. We think that it is not, as a matter of law, an obviously unimportant consideration for a reasonable purchaser of insurance to know that an undisclosed fee charged to a group insurance policyholder would be collected in addition to, rather than from, the actual cost of the insurance. The panel sent the Friedman case back to Pregerson for reconsideration. He dismissed the case again on November 1, 2019, with instructions that it cannot be refiled. Judge Pregerson criticized the lack of specificity of the third amended complaint and ruled the plaintiff failed to show they suffered any economic harm. Alan I. Schimmel of Sherman Oaks, CA, lead attorney for the plaintiffs, could not be reached for comment about whether the plaintiffs will appeal. Allowance renamed royalty. Court documents state the AARP created AARP Services, Inc. AARP, in 1999 pursuant to a settlement agreement with the Internal Revenue Service, following an investigation into income the AARP earned through endorsement deals. The AARP, a wholly owned subsidiary of the AARP, serves as its taxable for-profit division and negotiates, oversees, and manages lucrative contracts with AARP's insurance business partners. The AARP initially claimed an allowance for policy sales, but this was renamed a royalty after the IRS settlement.